Good morning, good afternoon, or good evening, depending on your time zone. It is my distinct pleasure to welcome you to this experts panel on bolstering national legal and institutional frameworks for climate action. This session is being hosted by the World Bank and the Ethiopian Civil Service University. I'll turn over to the chair now, who is Charlotte Streck. Charlotte is co-founder and lead consultant at Climate Focus, and she serves as an advisor to numerous governments and nonprofit organizations, private companies, and foundations on legal aspects of climate policy, international negotiations, policy development, and implementation. She's also a renowned international expert on climate change mitigation, forests, and agriculture. Prior to founding Climate Focus, Charlotte held the role of senior counsel with the World Bank and lead counsel for climate change with the Center for International Sustainable Development Law at McGill University. So with that, Charlotte, the floor is yours.
Thank you, and welcome to everybody to this very important session. Countries need laws, regulation, and institutions that implement the targets that they communicate in their NDCs. And these laws and institutions need to be fit for purpose. It's part of the whole discussion that we need to focus on implementation to make the transition to a climate positive world work. And the law is often underestimated in the role that it plays in this context, but it is absolutely essential, both on the level of the targets, but then also the implementation across the different line ministries. So for that reason that I'm delighted to have this in an extraordinary panel here. We will, over the next hour, look into legal and institutional frameworks that are enabling countries to implement their NDCs. We will, deep dive or dive deeply into Article 6 and the role of cooperative approaches and Article 6. And we, of course, have the utmost pleasure to also hear about a case study about what Ethiopia is doing to make its frameworks, its legal framework fit for purpose. I have a very distinguished panel here made of two World Bank lawyers. I'm particularly happy with this as a former World Bank lawyer myself. Remi, Moncel, and Fabiano de Andrade Correa. But then most importantly, we also have Mekonnen Maschal from the Ethiopian Civil Service University, which is essential because at the end, it is what happens in the countries, not what happens in Washington or in World Bank offices, what will change the world and make and equip the countries to implement their NDCs. And then, of course, we have Inyi Johnston she's a research associate from the Net Zero Aligned Offsetting at the University of Oxford, who will be a commentator on the session. So we have three presentations. Then I have prepared a number of questions. We have in here as commentators, and I'm very happy to also have questions from you. So we cannot have live questions, but you can formulate your questions and share them via the chat function. We will monitor what's coming in terms of questions. Some we may answer right away, others I will then elevate to the panel and we will discuss it with the group. With this, I don't think there was any kind of other logistics that I need to mention, so we can start with the presentation. So the first one is Remi Moncel. He is a senior counsel in the World Bank Environmental and International Law Unit. He works a lot with countries on their legal frameworks. Previously, he was a practicing lawyer. He also worked as senior associated with WRI, the World Resources Institute, in which capacity he was attending a lot of UNFCCC COPs and reporting back on those. He also was a judicial clerk at the U.S. District Court for the Northern District of California, and holds a degree from Berkeley Law School. With this, Remi, the floor is yours and welcome.
Thank you very much, Charlotte. Pleasure to be with all of you. Thanks to all my co-panelists as well, and to Maeve McDermott for her help organizing this session. Delighted to be here. I'd like to focus our remarks and our time here on the question of what is climate law and why does climate law matter? So I will ask for help projecting the slides. Thank you very much. So, what is climate law and why does it matter? So maybe we can start with an example of a climate law. So some of you may be familiar with the framework climate legislation that country of Uganda has adopted, and this is one of a growing number of framework climate laws that have been adopted by member countries in the aftermath of the Paris Agreement. So we can look at this example from Uganda to see that this law gives force to some of the provisions in the NDC for Uganda. It seeks to provide a framework for monitoring, reporting, and verifying the impacts of climate change and programmatic actions. It seeks to enhance the ability of the country of Uganda to adapt to the adverse impacts of climate change. It seeks to coordinate the institutional efforts at the country level to address climate change and provide some support for climate financing. So why does climate law matter? And why is this example significant? Well, we can just take a few examples, looking at the next slide, from the energy sector, for example. Your energy laws and regulations may need revision because they currently incentivize fossil fuel production. Or as another example, renewable energy and electric vehicle tax credits may be needed to encourage the adoption and uptake of low carbon technologies. Or a third example, government agencies may need new legal authority to collect and publish the information necessary to track a country's greenhouse gas emissions and policy implementation. So that's why climate law is needed to give legal force to national and international climate goals, to strengthen the country's ambition, and provide some legal certainty for the private sector and other stakeholders who want to see what the government intends to do and what the regulatory framework is going to be in the longer term. Now, what do we mean by climate law? Looking at the next slide. Most attendees here at COP and around the world are familiar with the relevant international law. So breezing through this, we have, of course, the UN Framework Convention on Climate Change and its Paris Agreement. The Kyoto Protocol, of course, is part of the background. But we also have emerging other sources of international law that are relevant. I just mentioned two here. The list is growing. The right to a clean, healthy, and sustainable environment, as recognized by the UN General Assembly, and international court decisions that are also bringing further details to this international legal framework, including the recent decision by the International Tribunal on the Law of the Sea. And what do we mean by climate law at the national level? Here we're talking about the country's climate-specific laws and regulations, but also climate-relevant laws and regulations. So not just a framework climate law like what we were looking at in Uganda, but also sector laws that may have a significant impact on the ability of a country to meet its climate objectives. We're also looking at the enabling legal environment. That's even a broader look at the legal and regulatory framework of the country. And essentially, it's the set of rules that are binding and enforceable in the country that are relevant to climate action. They're typically created by the legislative branch, but we shouldn't lose sight of the role of ministries or government agencies of the executive branch in issuing procedures, decrees, regulations that are also binding. And you have in a little diagram before you some examples of elements of the national legal framework. So basically, we're talking about constitution, laws, decrees, regulations at the national and at the subnational level, right? Let's not forget that are targeted at mitigation, adaptation, and help the country achieve its low carbon, climate resilient development objectives. So let's take a look at some of these elements in a little bit more detail. What we mean by this is, first, the overarching legal framework on climate change. So here, what would we be looking at? Because the goal, of course, is to think about not just what is climate law, but how do we tailor climate law to climate ambition? How can we improve national legal systems? How can we build compelling national legal systems for climate action? So that is some of the work that I and Fabiano and my colleagues at the World Bank do in providing technical assistance to member countries at their request. And so we ask a series of questions. So on the overarching climate change legal framework, I'll just give a few examples. We might ask, is there a national framework legislation, a piece of national framework legislation dedicated to climate change that is capable of giving the country's NDC legal force to enable its successful implementation? Is there similar legislation at the subnational level? Does the country's legal framework require the periodic completion of national and sectoral climate risks and vulnerability assessments? Those are some of the examples. Then, we look at the rule of law and administrative state. So that's the broader enabling environment I was talking about as well. So here we look at the systems and processes that govern how laws and regulations are made and enforced within a country. And we could look at, not just the legal environment as codified, but also the extent to which it is implemented in practice. So for example, if a country has a robust climate legislation, but it still encounters difficulties in enforcing the law based on, limited capacity or legal authority by the judiciary or executive agencies, that could be a hurdle to the effective implementation of the country's NDC, right? Likewise, in the Constitution, we can ask, does the country have a constitutional right to a healthy and clean environment or safe climate? There's a growing number of countries that have those provisions in their constitutions. And then I just give here a third example of an element, which is focused on countries' environmental and social impact assessment regulations. So here we ask, does the country's ESIA system require each major public and private project to undergo an ESIA, environmental and social impact assessment? And does that ESIA system require the consideration of climate impacts, both on mitigation, but also a climate vulnerability as part of the ESIA assessment? That's, an area of emerging good practice. It is something that we look at. On the next slide, we see maybe digging a little deeper on sectoral laws. If you look at the relevant sectors of the country, you can also ask the question of how well the laws and regulations in that sector are aligned with the country's NDC. So this doesn't necessarily mean looking at every single sector, although of course, as we know, as climate practitioners, virtually every sector is subject to climate risk and relevant for climate mitigation. But, for each country, one can identify the most relevant sectors, the ones that are the most vulnerable or the most relevant for climate ambition on the mitigation side, and ask the question of how well aligned the sectoral laws are. So we can ask, for example, to what extent the commitments and targets of the NDC are addressed in the sectoral laws and regulatory framework. Are the activities and actors most relevant in each sector actually bound by laws and regulations regarding their, climate relevant conduct or GHG emitting conduct? Are the regulations, the legal obligations sufficiently specific, unambiguous, compulsory? These are some of the questions. So maybe looking at the next slide, I want to bring to your attention a tool that the World Bank has developed. This is by Nick Menzies and some of my colleagues in the governance team at the bank that looks specifically at framework climate change legislation, like the example of Uganda at the start of this presentation. And it seeks to answer the question of what is a framework climate change law and what are some of the main elements that such a law should contain. So it's meant to be a guide, not too prescriptive, but highlighting some examples of country practices around the world from developed and developing countries, looking at the various elements, which I've reproduced in front of you here. I won't go into detail in the interest of time, but it is available online and I invite you to take a look. And on the next slide, you will see that it also surveys basically a sample of countries around the world and show, which countries have a framework law that contains all the relevant, elements. And of course, the list of countries is growing and changes year by year, and various laws are being amended. So this is a very fluid area of law. Next, I want to talk to you in the remaining minute or so I have about specific analyses that the World Bank has done. which is part of what the World Bank terms country climate and development reports. So these are interesting and analytical pieces produced by the World Bank for each member country, focused on trying to identify opportunities for development interventions that are also supportive of climate action. And as part of that assessment, we have on the legal side and legal team, Fabiano and I and our colleagues provided some recommendations for each CCDR where requested on possible ways to strengthen the national legal framework. So on the next slide, I will show you briefly the example of the analysis we did in Ghana, where we looked at relevant sector laws. We picked a few of the relevant sectors. We looked at Ghana's NDC, asking some of the questions that I was presenting earlier, right? And we came up with some areas of recommendation, which are on the next slide. And here, just highlighting an example or two, we saw that in the energy sector, for example, there was an opportunity to require more explicit climate coverage of particular sectors and actors. There was an opportunity in, the financing area to more directly and with more specificity allow for carbon financing tools, including carbon pricing and green taxation. And these CCDRs are publicly available. If you go on the World Bank's website and type in CCDR, you will see these analyses. I forget the number now, but it's several dozen, and Fabiano may be able to tell us in a moment. And in there, you will find for some of these countries more detailed legal analyses. This Ghana example, the work that we did, is also publicly available. And maybe I'll put the link in the chat after this presentation. So I will leave it here, and I'll be happy to answer questions later in the discussion. Thank you very much. Back to you, Charlotte.
Thank you very much. Very interesting. There was also a question on whether these presentations can be shared after the session. I leave this to the hosts to answer, but I think they are so dense and interesting that definitely that would be very much appreciated by our growing audience. With this, I now invite Fabiano de Andrade Correa, also Senior Legal Counsel with the World Bank. He is focusing on Article 6 implementation, so on cooperative approaches and market mechanisms under the Paris Agreement, among others, of course. He is, in his personal capacity, is also volunteers as co-chair of the Climate Change Law Specialists Group of the IUCN World Commission on Environmental Law. He is also a lead counsel on CISDL's SDG 16 programs, and holds a PhD and a Master of Law from the European University in Florence, and he is a member of the Brazilian Bar Association. Fabiano, the floor is yours.
Thank you very much, Charlotte, and a very early good morning from Washington, D.C. It's a real pleasure to be online here with you. I've had the pleasure of participating in these Climate Law and Governance Days many times in person. This year we are entirely online, but it's always a pleasure to gather the legal community around climate issues. And a pleasure really to participate in this session with fellow colleagues from the bank, with you, Charlotte, and everyone. I think we have a good audience online, which shows the growing interest in legal issues on climate change, which is really, really great to see. Let me start presenting my slides, but as Charlotte indicated, I will have actually a similar approach to what Remi was doing, but zooming in a little bit into the role of carbon markets for climate change action, and what can be elements of an enabling national legal framework to really allow countries to access and benefit from participating in carbon markets. Can my slides be seen correctly? Is it showing? Just to confirm.
Yes, all good, Fabiano. Okay. It's on the title page.
Thank you. So Just, very introductory remarks on why should we discuss this and what is it that we're talking about. As we know, climate change will have a series of very damaging impacts, and in economic terms, it's not going to be different. The World Economic Forum had predicted the cost of the damages of climate change to be something around 1.7 trillion and 3 trillion per year by 2050. New research suggests that that could be actually much higher, coming up to even 38 trillion a year. So that on the one hand, and on the other hand, if that was not enough, implementing the country's promises and aspirations in their NDCs is also extremely costly in the figures of around coming to 6 trillion by year, also by 2030. So basically, there's a lot of need of climate finance. Countries have, of course, been mobilizing for this in terms of, perhaps not everybody is super familiar with these figures, but since 2009, there has been a goal of 100 billion per year of climate finance mobilized by developed countries for developing countries. For the first time in 2022, this figure has been reached. But now one of the hot topics of the COP this year is, in fact, the discussion and definition of a new collective quantified goal for climate finance that will hopefully bring this figure up. However, we know and understand, as I was just explaining in the previous slide, that this is really a floor. We need much more than that if we are really to finance and allow a transition for our decarbonization towards net zero, which is what we really need. So new and innovative sources of climate finance are needed. And that's what brings me to the role of carbon markets. Carbon markets in themselves can be conceptualized as trading systems in which carbon credits, which can be defined as tradable units representing 1 ton of a CO2 equivalent, can be sold and purchased within a defined framework to meet either mandatory or voluntary greenhouse gas emission reduction commitments. They go back to the days of the Kyoto Protocol, which is the predecessor of the Paris Agreement, and emerged as a voluntary tool to support member parties in decarbonizing their economies in a cost-effective way. We can speak of compliance markets, which are framed around a mandatory framework, but also the voluntary carbon market, which, as we know, is growing a lot as well, and responds to increasingly emerging goals that companies and other actors also create for themselves. We can also speak of cap and trade systems in which carbon allowances are traded, or baseline and crediting systems in which carbon credits representing offsets are traded. And that's the type of markets that I will be focusing more on my presentation today. This, of course, has now been brought into the Paris Agreement with Article 6.2 and Article 6.4 mechanisms, which are also one of the very hot topics of the COP this year. We have had some decisions around this on the very first day of the COP. So if you're following, it's probably something that you will be seeing in the news. And then very quickly about the work of the World Bank in this area. The World Bank is, as Charlotte will remember probably, is an early actor in this area. It has been piloting carbon market approaches for over 20 years. I myself, in my role in the legal department, serve as a lawyer of 2 of the bank's carbon funds working in the forestry and agriculture sectors. And the bank has been really emphasizing lately the key role carbon markets can play in bringing debt-free additional finance for developing countries. And in fact, research that the bank has done shows that using carbon markets on a large scale could help reduce the cost of mitigation by 32%. So it really is not a silver bullet, I should say, and it doesn't replace the use of carbon markets doesn't replace mitigation efforts, but it's of course an important tool that countries can consider using in their strategies. So in terms of what can legislation look in this area, and I should emphasize the elements that I'll be presenting are not a checklist. They are not mandatory elements the countries must have, but rather areas of law the countries can consider and really enabling them to have a robust legal framework that allows them to benefit from carbon markets, but also to ensure high integrity carbon credits, which is really what we would be aiming for. To begin with, you know, as Remi emphasized, it's always important that countries have in place adequate policy goals so as to understand the direction of travel, and that can come from the NDCs, which usually outline climate and carbon finance needs and priorities. But it can also come from a national climate change policy and other sectoral policy documents that outline how much carbon finance the country needs, the sectors that it aims to use for this area of work, and so on and so forth. So once there is this adequate framework, countries can look into their legislation and understand if there are gaps, if there are areas that should be improved, or if even new legislation needs to be put in place. Which can be elements of this legal framework? To begin with, I think Remi also alluded to this, a governance or institutional framework is really key, with entities that can be in charge of climate change and given the necessary powers and mandates to act in this area. Examples of powers and competencies that such entities might have include the ability to approve projects or programs that will generate carbon credits, to serve as the designated national authority, for instance, for Article 6.4, which requires countries to have a DNA in place, the powers to authorize, for instance, actors to participate in carbon market activities, issuing licenses or permits or other instruments that would allow that, but also to authorize, for instance, certain carbon market transactions, such as corresponding adjustments and ITMOs, and we can discuss more about that. Importantly, the authority to enter into carbon market transactions, such as signing emission reduction purchase agreements, which is part of the work that I do here at the bank as well, we do sign ERPAs with countries to buy carbon credits, and it's always an important topic that we have, is ensuring that whoever is signing these agreements has the power to do so. Then entering into more substantive issues, it's of course very important that there is clarity on project or program development and implementation issues. And those include, of course, what kind of mitigation activities and program design elements the country is considering, coming also to the eligible methodologies and carbon credit mechanisms and baselines that will be used for such programs. Another issue that is important is if the country is considering allowing project approaches versus jurisdictional approaches. Both have the pros and cons, of course. Our programs in the bank, for instance, emphasize jurisdictional approaches because of scale and etc. But it is, of course, a decision, but it's important that there is clarity in what the country is allowing. Also, environmental and social integrity requirements, for instance, really elements related to permanence and additionality of carbon credits, which are crucial, but also respect for tenure rights and consultations and etc. Then issues related to the validation and monitoring, reporting, and verification, which are really key elements in all the process of generating carbon credits, which brings me to the carbon credit issuance and transactions. And I'm really sorry if I'm running a bit by slides, but I only have 10 minutes, and we can expand on any of these points in the Q&A. In terms of carbon credit issuance and transactions, it is also really important that the country has clarity and rules in these areas, And this includes all the issues related to certification and issuance of the credit. So how does that work? Who does what, and the process. A national registry is also a very important element that will allow countries to track the issuance of credits, track transactions, and have a place to register. The World Bank has been hosting the CATS, the Carbon Action Traction System, which has been supporting countries that do not have yet such a registry. But it is, of course, very important that countries develop their own and have a national system to monitor these issues, to track these issues. Then again, the issues of authorization of carbon credits. When we speak, for instance, of the Article 6.2 of the Paris Agreement, which really creates a framework for bilateral transactions, we then speak of the authorization of the carbon credits as an internationally transferred mitigation outcome, which requires a letter of authorization for a carbon credit to become one. And then also all the procedural aspects, which include performing a corresponding adjustment so as to avoid double counting. We have the integrity requirements that I spoke a little bit already, but then very important, and this is an issue that we also work a lot with countries from the World Bank side, legal ownership of carbon credits. So basically, who owns carbon? How does the law conceptualize this? And not only that, but also who has the ability to transact carbon credits. And that often also has a difference if we are speaking about a project-based approach or jurisdictional approach, in which governments often have the ability to transact in a centralized way. And then last but not least, the issue of the legal nature of carbon credits. So if carbon credits are considered a property right or security or other types of legal nature, which has implications in terms, for instance, of taxation and other issues.
Can you wrap up?
Yeah, I'm coming to the end. Final issues that countries can consider in terms of legislation include decisions on revenue use, including importantly benefit sharing mechanisms, reversal management mechanisms, which are particularly important in forestry related carbon credits, and dispute settlement mechanisms and enforcement. In these final two slides, I just copied an example of a legislation in this area that was recently adopted in Kenya. And you can see that many of the elements that I have been discussing are in fact included in this legislation. I'm not singling it out as a good practice or making any judgment on this particular piece of legislation, but just showing you that countries are already working in this area. So it's not a discussion in abstract. From the World Bank side, we have really been seeing a need of support in this area of law. So we have started to prepare a toolkit, a legal toolkit that will help countries in undertaking assessments and revising their legislations in this area of work. But I'll stop here and thank you very much for this, for the time to discuss this. And we'll be, of course, happy to answer any questions. Thank you very much. Back to you, Charlotte.
Yes, thank you. And we are all aware that these are complex issues, with a lot of things, to contemplate and discuss. So please, I encourage all our audience also to consult the World Bank resources. There is a lot, both on Article 6 as well as on legal frameworks. And a number of these resources also, or links to these resources also have been shared now in the chat, but more to come. Now, after this, what, in more abstract, what the World Bank can offer and what the World Bank is doing to support countries, let's look at the countries. And this is here, we are very, very happy to have Mekonnen Tarekegn. So I'm sorry for violating your last name. Here, he is assistant professor of the environmental science at the Ethiopian Civil Civil Service University. He is also a founder and principal consultant of the Global Environmental Solutions, a consulting firm. In this capacity, this consultancy firm has worked with a lot of these international organizations and focused on the implementation of different frameworks in Ethiopia. He has worked a lot on environmental social impact assessments and is also a certified technical reviewer under the Enhanced Transparency Framework of the Paris Agreement. He holds degrees in environmental science from the UNESCO IHE University in the Netherlands, and a PhD on environmental science from the Addis Ababa University in Ethiopia. And he comes with a lot of practical experience as well as, academic credentials. And we are very, very happy to have you here, Mekonnen. The floor is yours.
Okay, thank you. Thank you, Professor Charlotte. So good afternoon here, good morning and good evening there. So this is Mekonnen from Ethiopia. So I would like to give you my presentations, specifically focused on legal and regulatory framework for Article 6 implementation in Ethiopia. So I will give you the status of especially the policy and the legal framework that is potentially found in Ethiopian context.
And can you change your presentation to the presentation mode? So at the moment it works,
Yeah.
but we see it relatively smaller.
Okay.
If it's not, it's fine as well. It works also as well. But if
Yeah.
you can change to the presentation mode.
Okay, is it okay right now?
Perfect. Wonderful.
Okay. So thank you. So as you know, Ethiopia is found in the eastern part of Africa. It's just the most vulnerable country for climate change, in case its economy is dependent on erratic rainfall on agriculture. So because of this, the country has developed a climate change resilient green economic development plan and strategies in 2011. And also, endorsed in 2011. So the plan has integrated an adaptation and mitigation policy options with the economic development plan and actions. So the country has aimed, to reach a middle income status by 2025. Actually, during that time, during the development. So actually, the plan has integrated this adaptation and mitigation options to fight against this climate change. So the country has a lot of activities, previously have been, planned and implemented. So this CRG, Climate Change Resilient Green Economic Development Plan, has included this mitigation and adaptation that is highly, integrated with the climate action. So this CRG, Climate Change Resilient Green Economic Development Plan has become a base, for the development of, other climate-related policy and legislations. So this CRG has depended on 4 pillars: agriculture, forestry, power, industry, transport, and buildings. So the country has focused on low carbon development on these 4 pillars. Among these, the first, agriculture and forestry, has, the highest, greenhouse gas emissions. So in terms of CO2 equivalent, so the country has, put an ambitious plan, to reduce this, emissions from those agriculture and forestry. So based on this, the country has taken, has developed a growth and transformation plan 1 and 2. So growth and transformation plan in 2006. So integrated with the Paris Agreement. So in 2015, there was a Paris Agreement. So during this Paris Agreement, the country has prepared an intended NDC, nationally determined contributions based on the CRG and GTP2, and has submitted this INDC for Paris Agreement. And in 2007, when we see the CRG, milestones, in 2007, the country has developed a national adaptation plan and also signed the first, nationally determined contributions of the country. So to implement all these things, actually the country has used, the policy and the legal frameworks that have been, signed previously, before this time. Like, the country has shown the commitment in becoming an international, parties like a UNFCCC, a Kyoto Protocol, and the country has also accepted and used the Doha Amendment to the Kyoto Protocol. In 2017, officially the country has, signed the Paris Agreement, and in terms of, adaptations like climate change resulted disaster risk management. Sendai framework has been also accepted during this time, and also continentally the country has used the African Union's Agenda 2063 strategies, and have participated in the draft strategy on climate change 2015 strategy for African Union. So based on this international convention, summit, and agreement, the country has developed and passed many of the local policy and legal framework up to the standard level. So just to mention some of them, the country has developed NAPA in 2007, just from the ratification of Kyoto Protocol, and the country has prepared a UNFCCC INDCs in 2015, and also the country has submitted also the first NDC, national determined contribution, by 2017, and signed an agreement during this time, and officially ratified and prepared with targets of emission reductions during this time. So to meet this, the country has prepared a lot of actions based on the key categoric sectors, as you have seen here. So to implement all this stuff, the country has shown different commitments. Like, for example, when we see the GTP2 that was prepared in 2016, the country has prepared a 10-year national development plan from 2021 up to 2030, and focused on the environment and the climate change, diplomacy, and negotiations. In addition to this, during the preparation of this 2030, 10 years development plan, the country has focused on technological, financial, and capacity building support for emission reductions. When we go to the Paris Agreement, directly the Paris Agreement has linked all this policy and legal framework that was just ratified and signed in these previous years. So officially the country has ratified and put in proclamations in 2017 with proclamation number 1993 2017. So a lot of things have been mentioned here with these ratifications, like implementation of NDC, update of NDC. All the articles articulated on this Paris Agreement is accepted after this official issuance of this proclamation. So after this, just as per the demands of the Paris Agreement, and also the intention of the countries to implement the climate change resilient green economic development, just fighting against the climate change, Ethiopia has submitted the updated normal nationally determined contribution NDC by 2021. The one that you have seen here is on 10th of June 2015, that is intended NDC, initial NDC by 2011, and the updated NDC in 2021. So all these NDC have focused on these 4 pillars, like on agriculture, forestry, hydropower, and other infrastructure activities like on energy sectors. So when we see the Ethiopian NDC, like what I told you, it's submitted in 2001. So based on the stocktake of the Paris Agreement, so 21 mitigation and 18 adaptation actions have been identified and prepared here, and automatically from here the targets of 220.59 megatons of CO2 equivalent emissions have been planned to reduce as the target. So to reduce this, so the country has planned to use a financial of 294.72 billion USD requirement, and from here 20% has been planned to use from domestic source, and the other just conditionally from outside. But in general, in the first NDC, the country has planned to reduce 64% of the target. And whereas here in the update by 2021, the country has planned to reduce 68.8. So to implement this target, the country has also prepared a long-term, low emission development LT-LED plan. This is also one of the requirements in Paris Agreement. So the country has prepared this LT-LED by 2023. Of course, this one is a bit later than the preparation and the update of NDC, but as a requirement and also to align with the country's development plan, the country has prepared, this low emission development plan by 2023. Still, the plan has considered stakeholders, sectors, international cooperating party based on the Article 6, and emphasizing on the importance of the long-term sustainability and party cooperation. So to implement this, the country has, tried, partnering and finding the other international, parties working in cooperations to implement this, Article 6. As indication of this, in COP29, actually in these last 2 days that have been exposed here in Azerbaijan, the country has signed a memorandum of understanding with Russia, so to work together on Article 6 cooperations. The other thing in the country, that have been done on stakeholder engagement, because in the country, sector-wise, there are different sectors working together for this emission reduction and also implementation of this NDC. So as a coordinating agent, Ethiopian Environmental Protection Authority is found here as government institutions federally, and under the Ethiopian Environmental Protection Authority, Ministry of Water and Energy, Ministry of Mining, Ministry of Urban Development and Transport and Logistics, Ministry of Agriculture, Trade and Industry, Forestry Development, all these sectors have been identified to take all the actions, adaptation and mitigation policies from the NDC updates. One thing, in addition to this, Ministry of Planning and Development recently, it has become as a focal person, coordinating organization for Ethiopian NDC implementation. So Federal Environmental Protection Authority is found under this, the Ministry of Planning and Development. So Ministry of Planning and Development has taken the position as a focal institutions, government institutions, to coordinate and facilitate the sector offices, in collaboration, this Federal Environmental Authority, Federal Environmental Protection Authority. But whatever it is, Federal Environmental Authority, Protection Authority is also there to coordinate all the activities, including MRV, NDC implementation, and also the other, Article 6 implementations. In addition to this, the one that
can you wrap up? We are coming.
Yeah, okay. So there are MRV and monitoring and evaluations. So MRV directorate is also there. So in terms of, measuring, reporting and verification of the greenhouse gas emissions, and also this, monitoring and evaluations of the adaptation actions. So there are structures that is found in the ministry or in the Environmental Protection Authority. So in the Environmental Protection Authority, there is organized structure working on this. So when we come to the communication and the reporting, so the country has reported 1 time a biennial update report. Right now we call it a BTR, so biennial transparent report. So it's expected in 2025, in the next year. And national communication also, for the first time, something that is unique in Ethiopian case. So the first NC, National Communication, was reported in 2001 by the Ethiopian Meteorology Agency, and second National Communication reported in 2015. And the Planning and Development Minister also has reported the third National Communication in 2023. And the fourth one will be submitted, is underway by the Ministry of Planning and Development, something that we are just looking here as the challenges, just inconsistency of government organizations who are reporting this NDC. So the other thing, NDC updates. So NDC updates is updated for the first time in 2021 by updating mitigation measures and targets. And upon the requirements of Paris Agreement, we are also preparing to update the NDC by 2025 after 5 years. So the national inventory is also being carried out annually. Of course, it's being done for reporting every 2 years for BTR, whereas for national consumption, the Ethiopian government is also carrying out this MRV, national greenhouse gas inventory every year. So we are looking at this. In general, with additional ongoing activities, the country has built a platform for implementation of the Paris Agreement in general. Maybe we might have more information on these articles, 6 implementation on question and answer. Thank you.
Thank you. Thank you to all 3 panelists. Allow me, I have a small follow-on questions. I think we can stop sharing the screen. But Remi, what is the difference between law and policy? Why are, I think for non-lawyers, that may be the question. What does need to be put in a strategy and a policy documents? What needs to be in a guidance? What needs to be in a formal law? Can you shed light a bit on this?
Thanks, Charlotte. And Mekonnen, I think we can still see your slides. If you can unshare, be able to see each other better. But in the meantime, answering your question, Charlotte, thank you. Good question for lawyers and non-lawyers, I think. So I think policy and law, they serve different purposes and they need to work together. So we're not here, advocating against climate policy in favor of climate law. It's really that they need to go hand in hand. So climate policy is really about setting broad goals, objectives at the national level or subnational level, and priorities for particular sectors or for the country as a whole. Climate policy, again, this depends also on each country and its constitutional framework. But in general, climate policy and policy more generally is not binding. It's a strong indication of the political commitment and priorities of a given government. So it gives you a sense of what the government intends to do, and it's a good indication of what will happen. But typically, climate policies are not themselves legally binding. So in order to bring a binding force to specific commitments, you need to then anchor them in laws and regulations. And laws and regulations then become much more specific by specifying what the very clear obligation of an individual industry or economic actor is. So the laws and regulations are also provide more legal certainty. Policy is a broad goal, but it can change more easily. So it's more flexible. That's an advantage. But because it's so flexible and can change more easily, it gives less legal certainty to economic actors. If it's in law, typically it's harder to amend, and that's intentional. So it gives more visibility into the future, and that's very important for the private sector and private investment in particular. Thank you.
Fabiano, I will take now one of the questions from the audience here, and that is on Article 6.2 and also the power dynamics between potential buyers and sellers. So one worry is here that, of course, Article 6.2 gives flexibility to countries, but isn't there also the risk that then more powerful players impose their understanding of Article 6 on countries, on actors in developing countries? What is the World Bank's take on this? And well, yours, and is there any kind of assistance that the World Bank offers here to countries?
Thank you, Charlotte. I think it's not unintentional. The Article 6, in fact, has two sub-mechanisms, right? Article 6.2, as you mentioned, allows countries to transact bilaterally according to the rules that they define. So basically, it allows more flexibility in those transactions, whereas Article 6.4 is creating a centralized mechanism, the Paris Agreement crediting mechanism, that in which all parties to the Paris Agreement are coming together and discussing what rules will be applied. So in this sense, I think there is, these two different mechanisms give options to parties in what they decide to do. But of course, an underlying element in ensuring that there is fairness and adequate rules and the applicability of those rules is that there is a capacity at national level to understand what these mechanisms are, what these transactions entail. And we do see from the World Bank side a need for support and capacity development in many countries, not only developing countries, but across the board, really. So it's really important, I think, that different actors, different players in countries take an interest in this issue. I think is an area that is only going to expand because of what I discussed in my presentation, the resources that can be brought into countries through these transactions that are really crucial and needed in keeping forests standing, in helping countries to decarbonize. And lawyers, of course, have a key role to play in understanding what these rules are, the types of agreements that are used. And of course, there is still time to contribute. The rules of these articles, 6.2 and 6.4, are still being discussed at this very COP. So I think it's really crucial that these debates get more diffused and that there is support given to developing country lawyers in particular that can advise their governments and other actors in this sector.
And absolutely, and of course, Article 6.2 gives flexibility to the countries to define transactions and cooperative approaches so that they fit best for the countries. But of course, those that design these approaches and negotiate these agreements need to be equipped, capacitated, able to do so, and the World Bank and others, of course, play an important role. Mekonnen, we see all the great work that Ethiopia has done. So what is it what you can give others, what lessons you can share with others? What were the major challenges? What is the biggest problem in defining and also implementing these frameworks?
Okay, thank you, Charlotte. Actually, there are so many reforms till now, but I think just a few of them. And the first thing is just signing an agreement and the submission, updating of this, Paris Agreement. NDC update is one thing as a reform. So according to, this Paris Agreement, especially in the update, the national government has assigned national focal ministries. So in the focal ministries, they have already set a specific desk with just the following implementation of this Article 6. So there is a desk, separate desk, responsible for the implementation of this, Article 6 implementation from this Paris Agreement. And the next thing, I think actually as an activity level, but the CRG has its own, registry and desk. So the CRG means climate resilient green economies. So I think they are also implementing this, Paris Agreement based on CRGs. So based on this registry, I think they are just modifying and they are establishing a registry. So national MRV system will be registered here in local registry. This is also one of the reforms. And the other thing, maybe modifying these ministries, even the ministry, all the sectors are working under the Ministry of the follow-up of the Ministry of Planning and Development. these 7-8 ministry offices. They are responsible for these ministries. So bringing this, Article 6 and MRV system totally from the one separate environmental protection authority to the Ministry of Planning and Development is also another reform, because I think the follow-up, the data flow from the lower ministry level towards, the planning and ministry offices are one of the suitable options, even according to the context of Ethiopia organizational structures. So we can just consider this one another reform. And the other thing, maybe capacity building. Continuous capacity building was given, even as I remember, as just there was no any, tracking framework for NDC implementation, checking whether the targets are achieved or not. So right now they have developed a GASIMO-based, a greenhouse gas abatement cost model. GASIMO model-based, actually it is a UNIV CCC model. So they have developed a tracking framework to follow this. They have, prepared a tracking framework for NDC implementation, including this. I think there are also other things, like identifying and signing a memorandum of understanding with the host parties, to perform ETMOS and other, carbon market strategies. So there are many things that we can mention as an opportunity here in Ethiopia. We used, still CRG plan. So the country 10 years development plan. So we have just allocated the finance for implementation of a national economic development plan. So at the same time, we are implementing here, the country is implementing the, this Paris Agreement. So about 20% of the budget allocated for this, Paris Agreement or Article 6 implementation, NDC implementation, can be part of that, CRG development plan or the 10 years development plan implementation. So I think we can take this one as, an opportunity. The other challenges is still there is a knowledge gap.
Yeah, I think there may be less.
Okay, thank you.
Let's leave it with this, but that's very interesting.
Okay.
I think what is also important, to understand that many developing countries haven't spent so much time on implementing Article 6 as developing countries. So from my experience, you should never feel bad, because the other side may, present themselves as if they had understood everything. Often they haven't. I can tell you that for sure. So we are, we only have about 7-8 minutes left. Inyi, you are invited here as commentator and as discussant, and also you may also have a number of questions, but most importantly also observations. You are a research fellow at the University of Oxford Net Zero Aligned Offsetting Program and an associate member of St. Anthony's College, also a lawyer and a keen observer of what's going on. You are also, I think, the only one that is now in Baku, so please share your impressions.
Yeah, thank you so much, Charlotte. I'm hoping everyone can hear me. I'm literally on the ground at COP, as always these things operate. But I did just want to contextualize this whole discussion, given the theme of this COP as a finance COP. And I think what's really interesting, because although Article 6 is on the table alongside this NCQG that we heard about earlier, really it's this whole question of not only how we grow the pie of funding, how we allocate that funding, and what kind of proportions of private sector money and public sector money make up that. And I think this is why it's really useful when contextualizing the appropriate role of carbon markets. We do critically think, what is the appropriate role of each kind of financing stream? And kind of building off Remi's framework that he introduced about, these framework laws on climate change, really the Paris Agreement adopts the same kind of framework approach. And through the NDCs, that's where we get more specifications. And so I think what's really interesting is, as we see with the provisions under Article 6, similarly, we are now getting to that substantive end of it. So we've got the framework, we know we need to ratchet, but we're getting to that substantive end. And I would just like to say as well that the Paris Agreement is a package. We've got Article 5, we've got Article 9, as well as Article 6 in terms of potential financing streams. And again, we have to really critically think, what is the role each can play within this? And at the same time, and as we've seen some questions coming through, you know, Article 6 was designed to learn a lot of the lessons from market mechanism implementation in past, and that's both more compliance-based mechanisms, such as we had under the Kyoto Protocol, but also lessons learned in terms of project implementation by the voluntary carbon market. And I really appreciated the questions, for instance, about how to protect Indigenous rights, because this is one of those areas that Article 6 has seen some innovations in terms of allowing an independent grievance mechanism. But it's also done that in terms of stepping us out of a ton-for-ton approach. For instance, under 6.4, parties actually have to cancel more units as part of a contribution to actually mitigating global emissions rather than just substituting emissions. And that's an important distinction, especially as it cuts to the core of, do these mechanisms actually work to reduce emissions, or do they just seek to shuffle around whose responsibility they are? And as we've seen, another question in the chat is really about capacity, and especially under Article 6.2, where there is such a wide range of diverging views about its role and its potential. And it's really interesting because here on the ground, there's the exact same thing. So we have some parties that are having events about how 6.2 could encourage a transition to gas technologies, you know, whereas others are really looking at how to use it in terms of leapfrogging certain technologies such as that. And I think now that we're in the substantive phase, it's really critical to examine these tools and examine what they can contribute and where, again, that they could have their limitations. And I think more than anything, and as we stand from at Oxford, we're really concerned right now about the net zero alignment of the system. Again, because the units under Article 6 do not distinguish between reductions and removals and within different categories within that. And again, so I think we have to treat this mechanism similar to the Paris Agreement in terms of we'll get some framework rules like we concluded here at this COP, but we really have to be thinking about how we can ratchet in line with the best available science. And here is where I think it's really critical to have this strong interface between these, between domestic laws and lessons learned from Article 6 implementation to feed back up into the international process, for instance, the Article 6.4 supervisory bodies procedures going forward. So really we need to kind of bring in this framework approach, but with one that also allows sufficient flexibility to kind of expand on from there. And so just kind of, I guess, based on that, I was keen to hear from Remi and just really understand, how do you see we best strike that balance between setting like a clear pathway and in terms of a framework climate law or other type of policy, but still enabling that flexibility to adjust and to course correct and to pivot in line with science or other kind of domestic developments?
And I realized, Remi, this is also the last intervention. And let me add one question from the chat also to Ini's question. And that is, what are your suggestions for domestic lawyers? What is their role and what they should focus on here?
Thank you both. Flexibility and law can go together. I mentioned earlier that one of the advantages of law is that it's less flexible because it gives more certainty. But you're right, we need to keep some flexibility to adapt to the evolving science, to latest developments at the national level as well. And so this framework guide, this guide on framework legislation that Maeve put in the chat, prepared by the World Bank, has a list of elements that we suggest countries consider, and one of them is precisely reviewing latest developments and having an adaptive management approach. So there can be in the law also provisions for reviewing the extent to which the country needs to adjust course or strengthen its approach or even revise the law itself. So I think that's a good tool. And then Charlotte, the question from the colleague in the chat. Many things lawyers could do, but I think the question you asked me at the beginning is one I think as lawyers we understand better maybe than some of our non-lawyer friends. And that's a role that domestic lawyers can play, helping policymakers understand the significance of law in the climate ambition journey, helping them understand why it's so important to integrate in law some of these broader climate policy goals and helping our national country colleagues do that as lawyers. I think that's an important role we can play.
Thank you very much, and thanks to the whole panel. Unfortunately, we are at time now. Of course, there are many unanswered questions. One on the logistics, I can say that the organizers will seek to share the presentations as well as the recording with everybody who has registered. Please get in touch if you haven't received these documents by end of the day or by tomorrow. Thank you very much, and good luck in Baku, in Washington, in Addis, everywhere, and keep on with your great work. Thank you very much. Bye-bye.